Hello everyone. Bonsoir à tous et bienvenue à cette rencontre du comité de dérogation pour la Ville d'Ottawa. Welcome to the City of Ottawa's Committee of Adjustment hearing. It's an online hearing, as you can tell this evening. My name is Anne Tremblay, and with me tonight is Mr. Scott Hindle, Mr. Colin White, and Ms. Kathleen Willis. We also have a number of committee staff who are here to help us. And that would be tonight Mr. Matthew Garnett, Ms. Cheryl Williams. I believe we also have Ms. Emily Manette and Ms. Mandy Nguyen helping us out as well. So we have lots of help with us this evening. The Committee of Adjustment, as you know, is a quasi, or if you've never tuned in before, maybe you don't, is a quasi-judicial tribunal appointed by City Council to make decisions on applications under the Planning Act. And the ones that are most common are essentially minor variances and consents to sever. But we also do deal with permissions, and we do have one this evening that we will be dealing with. So, with that, there are a number of issues surrounding development in the city that can impact things that are going on. But the Committee of Adjustment itself, our mandate is quite narrow. The kinds of things that we can only deal with, for example, are related to the applications. So not things like aspects of the proposal to which there is, in fact, nothing before us. So if there's an aspect about the development for which a minor variance isn't required, we can't get into discussion about some of those things. We don't get into any discussion about noise pollution, property maintenance, property values, that kind of thing, prosecution for illegal construction, or also any personal comments. We won't entertain any personal comments about either the applicant, the owner, or anyone participating in these proceedings. And also we can't entertain any new minor variances or greater relief from a minor variance that's before us in an application. So in terms of the process, there is an agenda that you saw at the outset of the meeting. We have an opportunity to, at the chair's discretion, to in fact play a little bit with that order. And that's what we're going to do this evening, because we have some applications that we can fast track. It's been a little bit easier to do that with online hearings. So, so you'll notice that there is a little bit of a change in the order. In terms of the process, what typically happens is we'll call down an application. We can opt to either hear a presentation from the applicant or the agent, or to go straight to questions. If we go straight to questions, then what happens is that it's the panel itself who has a chance to ask questions in order to make sure that they have understood everything there is about the application. Now, I should say that the members of the panel do have an opportunity to look at all of the information that's on file prior to actually coming to the meeting this evening. So we're fairly familiar with what's going on, from at least from a technical standpoint, but sometimes there's other aspects of the application that can come forward, or that we have that we may want some clarity on. And so that's when the committee members get a chance to ask them questions to get that clarity. From that point on, we can open up the public portion of the hearing, where if in some cases I have speakers that I can ask to come forward. And then if there's anybody who has an interest in the application who isn't on my speakers list, you of course can address the panel. All you'll need to do is to hold up your hand, raise your hand when we get to that point, and the committee coordinator will bring you in so that you can ask your questions and get some answers. Once that is done, the committee members may in fact want to ask you questions as well for clarification. After all of that discussion is done, then we close down the public portion of the meeting, and then the panel members will have a chance to deliberate in order to reach a decision. So in terms of the decisions, the panel can, in fact, obviously grant an application, can refuse an application, can also reserve an application, and that happens when we have a lot of new submissions and evidence is brought forward to us as part of the public portion of the hearing. And then, of course, the other thing that the committee can do is to adjourn the meeting altogether to another date or sine die, so that we don't pick in particular a new time frame. Once a decision is rendered, there's a written portion that is then mailed out to everyone who has an interest in the application. And in that decision, that written decision, there is all of the reasons for which the panel made a decision. From there, there's a 20-day appeal period to which, if you don't agree with the decision by the committee, you have the opportunity to appeal that decision to the local planning appeal tribunal, and there is a fee attached to that. So I think at this point that pretty much wraps up some of the instructions that we have to lay out. I am going to go to the orders of business at this point. Is there any member who has a conflict of interest with any of the matters that are before us either tonight or that were before another panel earlier in the day? All right, seeing no conflicts of interest, that's great. Second item of business typically is minutes. We do not have any minutes to approve for tonight, so we can go on to the next portion, which is to deal with some of the adjournments. So we have one adjournment that we can bring forward. We have one, in fact, there's been a request, and the other one that we will want to talk about with an applicant. So I'm going to call forward application number 7, which is for Buttonfield, 6078 Buttonfield. And I believe I'm looking for a Ms. Bakash, if I'm correct. Do we have? Yes, I think I see that. Yep, come on forward.
Hi there, good afternoon.
Oh, sorry, terribly sorry. Nice to see you this evening. So you're aware that in fact the phase 2 ESA is outstanding on your application?
Yes, I am.
Okay. And you've requested an adjournment to a later timeframe so that you can get that phase 2 report into staff for their review?
Yes, that's correct. I'm requesting if it's possible to have an adjournment either the first week of June, if possible, due to some complications.
Okay, so if that's the case, then I had sort of a May date in mind. Mr. Garnett, could you tell me what the first meeting in June is, please?
Yes, Madam Chair, that would bring us to June 2nd.
June 2nd. All right. Okay, does the committee have any questions for Mr. Bakash about that adjournment request? All right. I don't have anybody on docket to speak to this item, but is there anyone who wants to speak either for or against the request for adjournment to June 2nd? Okay, I'm not seeing anybody raise their hand. So on that basis, committee members, all in favor to a adjournment? Thank you. Okay, so it's unanimous. The committee is adjourning this application until June 2nd, and we look forward to the results of your phase 2 environmental study.
Excellent. Thank you so much for your time, and I greatly appreciate the accommodations.
All right, no problem. Thanks so much.
Take care.
You too. Okay, so we're going to, at this point, application number 10. I'm looking for Mr. Pioto. I'm hoping I'm pronouncing that correctly. Do we have Mr. Pioto? Miss Heron would be.
Libby's. All right, I'm here.
Hello. Okay, so on your application, we noted that there is a revision to the relief that's required from the zoning bylaw. So what's been sort of flagged to us is that we're looking at an increase in the cumulative floor area of 58.28 rather than just 58. So we've got an extra 0.28 in there. Is that correct?
Yes, that was a rounding assumption on my part.
Okay, so we've got Mr. Hodgins, I think, as the planner. We're in a situation, Mr. Pioto, that if there's any increased relief required, then typically what the advice that we've been given is that in order to ensure due public process, that the application actually has to be recirculated. So there's two options here. Either we can adjourn, allow for that recirculation, and go to the May 5th meeting. No, we won't make the May 5th meeting. We will make the May 19th meeting. If that's the case, we can do that. But the other option is to in fact stick with what the application was actually for, which is for an increased cumulative floor area of 58 square meters. Is it possible to adjust your plans in order to do that?
Yes, absolutely. I spoke with Cameron yesterday and sent him an updated plan which reduced the studio length by 3 inches, and that accommodated the 58 limit.
All right, in which case we will not need to adjourn your application.
Correct.
And all right, so don't go away. So committee members, any questions about any of that? No? All right. So I think what we'll do, and just pardon me, I'm juggling laptops this evening. So I think what we'll do then, I don't have anyone to speak to this item, but is there anyone in the audience who wants to speak either for or against? No, sorry, we don't need to do that because it was our request for potential adjournment. So that's fine. We'll deal with you first then. I think that's the best way to go since you're already there. So in that case, members, if you're all in agreement, then we can actually start with the hearing items now, and we'll start with Mr. Piotto. Wasn't the first one we were going to start with, but that's fine in any event. So I don't believe I have a statutory declaration for this application, right? Number 10. No, we don't. All right. So Mr. Piotto, I need you to either swear or affirm that the sign that was provided to you as part of the process and by the committee was on the property to which the application applies, that it was there for the prescribed amount of time prior to the hearing, and that the sign was clearly visible and legible for the entirety of that time. Can you either swear or affirm that to be true?
I swear that that's true, yes.
All right, thank you very much. Okay, so we don't need a presentation. We've had a look at all of the background material on this file. I'm going to open it up to the members of the committee for any questions at this point. Mr. White, please go ahead.
Thank you, Madam Chair. I just noticed in the report that we received from the planning branch from Mr. Hodgins, there is some discussion about the lack of a tree information report. And that was one of the reasons given as well, requesting an adjournment until such time as the tree protection bylaw tree information report is prepared. I'm wondering if that's still a concern or if we can condition that.
That was an arborist was brought in on the weekend, and on Monday she produced a report for us, which was presented to Nancy Young, and I believe that she has approved that report as part of the process.
All right, we're going to bring Ms. Young forward, if she could, please. We just need confirmation from you, Ms. Young. I want to be sure that you got a report, that it has the detail that it needed, and that you've had sufficient time to, in fact, review it in order to form an opinion about it.
Yes, so through you, Madam Chair, we did receive the report on Monday, and it covers everything that I need it to cover. And I have no further concerns about the one tree that will not be removed. It's just near the development.
All right, thank you very much. Any further questions from the committee? Nope, I'm not seeing any further hands up on this application. I also, again, don't have anyone to speak to this application. Is there anyone in the audience who would like to either speak for or against this application? This is your chance, and all you need to do is to raise your hand. And if you're on the phone, I believe it's *6.
Madam Chair, perhaps while we wait for, if there's anyone in the public that wants to speak, would just ask on behalf of committee staff if the revised plan hasn't been filed, that it be.
That's a good
to our
question,
office as well.
Mr. Garnett. Mr. Hodgins, you've seen the revised plan, right? So you've had a chance to sign off on this?
Yes, thank you, Madam Chair. I have seen the revised plans and I'm okay. I will forward them off to the committee staff.
Okay, so we don't actually have that plan in hand right now, but we will in order for the decision. Okay. All right, thanks. And I didn't see anyone come forward at all. So I think members, we're at the point where we can vote on this item. So all those in favor of the application? All right, thank you. So the application is unanimously granted for the record. And I don't believe there's anything else that we really need to talk about. Mr. Pietro, I think we've got, you've got the comments from Hydro Ottawa, right? You're familiar with their requirements for their modifications. And you've got a, you're gonna need a heritage permit as part of the process.
Yes, that's in the process, yes.
Okay, and I think that's it. There's no other information items that I have to go over with you. So good luck with the heritage permit.
Thank you very much. Thank you, Cameron and Nancy and Mackenzie Kim for helping me through this process.
All right, thank you very much. We appreciate that. Okay, so we're going to go to the next application. We're going to go to 98 Côte des Neiges. I'm looking for Mr. Segreto. Mr. Segreto.
Good evening, Madam Chair.
Good evening, Mr. Segreto. I don't have a stat deck from you, so can you either swear or affirm that the post, the sign provided to you as part of the process and by the committee was posted on the property to which the application applies for the prescribed number of days prior to the hearing, and that it was clearly legible and visible for the entirety of that time? Do you either swear or affirm that to be true?
I swear.
All right, thank you. So I don't think we're going to ask you for a presentation, Mr. Segreto. So we're becoming very familiar with these applications. Typically, we do ask when we've got members of the public who would like to speak. We have the community association representatives who will join us in a few minutes. But I think at this point, we're just going to go straight to the committee and allow the committee to ask any questions or clarification at this point.
No problem.
Anyone? Mr. White. Mr. White.
Thank you, Madam Chair. Just a comment with respect to Mr. Segreto's submission. I note in his submission, he's provided a very comprehensive and I think obviously well-researched list of similar minor variance situations across the neighborhood. I didn't count the number, but it's probably something in the 70, 75 property range where identical or very similar minor variances for substantially reducing the lot width and lot area requirements through the Committee of Adjustment has obviously taken place. That just supports my position on these applications that the Committee of Adjustment has been involved over the last, and I would say it's the last 8 to 10 years or so, in terms of a impact on the community that's tantamount to amending the zoning bylaw in the absence of what normally would be required as a comprehensive zoning review, as a review of the neighborhood issues such as servicing, adequacy of parkland, all those sorts of things, which has not taken place. I'm still of the view that these minor variances are inconsistent with the general purpose and intent of the zoning bylaw, which is out of step and has been out of step with the adopted official plan in terms of intensification policies. So I'm still of the view that these are inconsistent with the general purpose and intent. I will be dissenting on the application for that reason. But I appreciate the information that Mr. Segreto has provided, and I would suggest that it would be useful for the city to review that information and take a look at the zoning bylaw in greater depth, because the community has been significantly changed from its character that was incorporated. It was part of the original zoning provisions, which have been in place since 1962. And on that basis, I'm going to dissent on this application.
All right, thank you, Mr. White. Any other questions or comments? Yes, Mr. Hindle.
Yeah, I had a question for Ms. Young. I noticed in the staff report that it talks to trees number 3 and 6, but trees number 2 and 5 are also proposed to be removed from the TIR. Could you just give me a sense that you're okay with the proposal to remove all 4 trees?
Thank you. Through you, Madam Chair. I basically chose to comment only on the trees that are impacted by the variances and the severance proposed. I feel like tree number 2 and tree number 5 are outside of that area, and the decision on whether or not to remove those trees would be more appropriate at the building permit stage. I think they need a closer look by forestry on whether or not it's appropriate to remove them.
Okay, no, that's super helpful. Thank you.
Ms. Young, don't go away. I have a question. When Mr. Hindle started down that route, I thought, oh, I think he's going to get where I'm going, and he did. Sorry, Mr. Segreto.
I did talk with the community association, with Miss Nancy and with Miss Jill, and I did talk with my client as well. And my client is in a position that for tree number 5, which is at the back of the property of part 1, my client is more than willing to protect that tree and to retain that tree. So my understanding is that tree number 5, we can save that tree and we're not going to take it down or get rid of it. Number 2 is a little bit different. If we can, I think we might try to save that one as well, but definitely number 5, as outlined on the report where they say that we can remove it, my client or the owner of the property is willing to protect it and to retain that tree there for sure, just so the committee knows.
All right, thank you, Mr. Segreto. That's helpful. So Ms. Young, I guess my question is, so we're looking at trees number 3 and 6, and if I understand correctly, the reason for your focus on those trees is because they're directly impacted by the actual development and the minor variances that come with that. So, but from a process standpoint, I'm actually interested a little bit about how this would work. So your comments indicate that there needs to be essentially a written permission through with a neighbor. So the tree number 6, you say, is jointly owned, and to issue a permit for the removal of that jointly owned tree, the city requires permissions from both neighbors. Can you just describe for me a little bit what that process is about? Ms. Young?
Yes, the process is a result. Well, forestry can't issue. Oh, am I frozen?
No, you're okay now. We can hear you.
I'm hoping you can still hear me. Okay, sorry for that. So the process is that forestry can't issue a permit for a tree that's owned by someone else or partially by someone else. So where a tree like number 6 is impacted by a development, forestry says they can issue a permit as long as the neighbor or the joint owner provides permission to remove. So in this case, the neighbor has provided that permission. So that means we don't need to work to change the plan so that that tree is retained.
All right, so that never should be a condition of approval. It's in fact a permission that needs to be signed off as part of your review of the tree information report. Okay,
Yes.
that was not something I had picked up on before, so thank you so much for that. I better understand now how all that happens. Anybody have any other questions about either the trees or anything, any other aspect that you would like clarification for? Okay, I'm not seeing the committee members come forward with any more questions, so at this point we can go to the public portion of the hearing. And we've got two persons registered to speak. We have Ms. Jill Pratt and Ms. Nancy Wilson. So I see Ms. Pratt, you are here, and I see Ms. Wilson is here as well. Who will be taking the lead on the comments?
Nancy Wilson.
All right, thank you. Ms. Wilson.
Hi,
Hello.
can you hear me?
We can hear you. We can't see you, but we can hear
Hi.
you.
Do you need to see me?
No, it's not absolutely necessary, Ms. Wilson, so go ahead.
Let me see. Okay. It's just that I had my shot yesterday and there I am. I have my shot yesterday and I'm flat out in bed with a bad headache. So I'm just gonna shut the video off if that's okay.
That's
Okay.
fine. That's fine.
First of all, we realized that in City View, the 50-foot lots have become a part, like a norm, even though the bylaw says 65 feet. So we have to object because of that. We believe that the bylaw should be respected. The character of the neighborhood. A good example of that is there's two houses across that have been built and two houses beside that have been built. Those houses are built by a builder who respects the character of our neighborhood, and they show, and I think you've got some pictures there of them, they show what kind of houses are respecting the character of our neighborhood. Not all of the houses are, but that's just something that we wanted to bring to your attention, is that some of the houses do respect the character of our neighborhood. The last thing that I wanted to talk about is the trees. And the diagram that you have that shows the different trees, and we did talk to Mr. Segreto about this. He's saying that they will keep the apple trees in the back, which is great. But we think that number 2 tree in the front, because it's not, the driveway's beside it, the house is basically where the house is now. And I think that number 2 tree could be saved, and I think it should be saved. It's a substantial tree. It's a beautiful tree, and it should be saved. The other thing that these tree reports that are out, they've got number 7 and number 1, which are on the other properties. And I understand 1 is right on the edge of the property, so it could be impacted. But number 7, I don't even know why it's on there, because it's way over on the neighbor's front of their property. So it looks like, I'm not quite sure why it's in that report. The other tree that we're concerned about is number 6. I did talk to Nancy Young about it, and I guess because it's in the path of the build, it can't be saved. We'd like to see it saved. But so tree number 6 and tree number 2 we think should be saved, but definitely tree number 2. And that's really about all that I have to say. I think Jill has some other things to say. So I just wanted to talk about the trees and the
Right. Well, thank you, Ms. Wilson. I was just going to ask the coordinator, if the coordinator could please just put that plan up. I'm looking for it. There's a lot of material and I haven't been able to put my finger on it, but we did have the plan, and just so that we can understand exactly which trees we're talking about. Is it possible to get just that?
City report. It's in the city report there, so.
Yeah, I did see it. I just can't seem to get it. Like I've got quite a bit of material here and I can't seem to put my fingers on it very quickly. Is that the one I'm looking for? No, I believe it's the one that actually forms part of the report. Yes, I think Mr. Hindle is doing his best to help us.
In our agenda, Madam Chair.
Yeah, I'm just trying to find it. I know we had it. All right, so Mr. Hindle is showing it, but I think it would, I found, okay, so I found it finally. It's the very last page. Thank you. Oh, that's why I was having trouble. All
there
right,
we go.
So Ms. Wilson, I just want to be sure we understand. So the number 7 you're saying is clearly off the site. And it's number 4. Was it number 4 that you were talking about in terms of trying to save that one?
Number 4 is the apple trees that Mr. Segreto said that they've agreed to save in the backyard.
All right,
So
okay.
but it's number 2 that we're most concerned about. And if you look, you can see the driveway running beside, and you can see the front of the house is just nicking the root ball of that. And I think that number 2 could be saved on that green space in the front, just like it sits. The other one is number 6, but it's very, very close to the edge of that house. So the only thing you could do is shrink the house, which I'm sure is not going to happen. So number 6 is probably going to have to go. But number 2, I think, is one that should be looked at and saved.
All right, thank you. Mr. Segreto, just remind me, I know you addressed this in your opening comments there.
Madam Chair, as I said, number 5 in the back, my clients are more than happy to protect it. And I believe I can convince my clients as well for number 2, because I can look at it myself as I see it myself. I think there's a possibility of saving that. There's no reason why we can't. So I would concur and I would agree with Nancy that number 5 and number 2 we can save. Number 6 obviously is just too close to the property line and too close to the foundation. That one we can't. So number 2 and number 5 would be more than happy. I would be more than happy, and I would agree to save those trees. And that's where I stand right now on that.
All right,
Mr.
thank you.
Segreto,
Thank you.
Were you talking about number 4 or number 5? Because number 4 is the apple trees in the back, and I think
Number four is going to be there. We've already agreed to keep number 4.
Oh, okay. Okay.
Yeah.
So you're talking about number 5 also. Okay.
I think number 5 we can save as well.
Okay. That's great.
All right, thank you. I just wanted to make sure everybody was clear on what we were talking about here. And in these cases, it really helps to have a visual. Ms. Pratt, I believe you're up next.
All right. I just want to reiterate what Mr. White said. We've been lots of these committee of adjustment meetings, and we've fought against the size of these buildings, but we and your 4 requirements, but we never won any of them. So I'm not going to waste my time here tonight. There are 2 issues that I do want to address. We're always concerned about our existing infrastructure and whether it can continue to maintain these large infills with multiple bathrooms and a lot more people. Mostly we're concerned about drainage in this area. We'd like to note that the excavation of ditches and piping under driveways are required in our community because we have no storm sewers here. When 2 large houses replace a single home on their property, our community drainage is drastically affected. When the existing expanse of green space and trees that absorb stormwater is removed and replaced with houses that cover more than 45% of the property, in addition with 2 car-wide impermeable driveways, front porches, and rear decks, it's impossible. It's important that stormwater be directed outwards and into the ditches and not to the surrounding properties. We've had recent discussions with the City of Ottawa, and we're advised that ditches and piping under driveways are a requirement of construction in our area. And the city, we have the city now currently reviewing a number of infills that are under construction in the community to make sure that this work is done. So I don't know why this requirement isn't included in the conditions of these builds.
All right. So I think I can answer that, Ms. Pratt. Conditions of
I know what the
development.
answer is.
Well, so let me just, for the benefit of maybe others that are listening in, the reason why that there's no condition is because, as you know, there's no consent application that's required. And that's how conditions of development are actually imposed. They're not imposed through minor variances. So, but that said, in this case, and what would typically happen if there was a consent is that there would be the normal grading and drainage condition that we always impose on any creation of a new lot. And that's intended to ensure that all post-development flows are dealt with on site, and that there's proper grading and there's sufficient ability for the lands to in fact, deal with the added flows. So in this case, it's left to the building permit process, and that's how grading and drainage is then dealt with, and it's dealt with on a site-by-site basis. So my understanding is that the committee's concerns and the community association's concerns with regards to some of the stormwater management issues in this area are now well known to city, and I'm actually very encouraged to hear that they're beginning to look at several of these developments that have occurred and that are under development, so that they can look at a cumulative impact of that over time. So I don't think that does everything you wanted to do in terms of responding to your concerns, but I'm hoping that that's at least a step in the right direction. Ms. Pratt, I'm going to go ahead and respond because we've been dealing with you, and then I'll come back to Ms. Wilson.
I'm sorry. Yes, thank you very much. Actually, you gave me some information I didn't even know. But I did want to make another comment. And we just like to add for the record that, again, in this case, because there's no severance, the ward, the community, and the city all lose out on their cash in lieu of parkland funds for this piece of property. Because of this anomaly of historic 25-foot lots here in City View that were established in 1913, our community has lost out on hundreds of thousands of dollars from this fund. And we lack parkland, but we can't seem to get this money. We're continuing to lobby the city for changes on the way they collect these fees. In Toronto, it's based on a different way than it is here. Here they wait until, I guess, the permit's set out. But we brought this issue up to the city in January of 2018, and they agreed at that time that they were going to address it. We continue to bring it up. A motion was brought forward back in the fall, and it wasn't properly addressed, and we're still going after the councillors and the city to make sure this gets corrected.
All right, thank you.
5 or 6 more severances coming up in the next couple of months. Thank you.
Thank you, Ms. Fred. I appreciate that update too, so thank you. Ms. Wilson, and then I'll go to Mr. White. Ms. Wilson, you had your hand up. Did you still want to speak? All right.
I just wanted to bring up the cash in lieu, but Jill brought it up because we have lost out a lot of money because of the cash in lieu problem. So we are working on getting that corrected to get it not based on severance, but based on something different. So thank you very much, and thank you for your time.
All right, thank you, Ms. Wilson. Thank you, Ms. Pratt. Mr. White, your hand is up.
Thank you, Madam Chair. On that cash in lieu of parkland, could I ask a question, please, of staff? We're creating, I mean, this is essentially creating, doubling the number of units on the original parcel. Is there a cash in lieu payment taken as a condition of the building permit?
Madam Chair, for the question, cash in lieu is not collected at the building permit stage. No.
Thank you, Madam Chair. I think that goes to my point that the deficiency of parkland here with the number and scope of the minor variances that have been granted in this area does nothing in terms of addressing that parkland deficiency issue that's been recognized or identified by the community and by some planners in the former.
No, it's okay. Talk to me for a minute.
Sorry, Ms. Wilson. Okay. Thank you. All right, I agree. There's definitely a loophole in these situations, and the community is unfortunately the ones that lose out in these cases. So, any other questions for our speakers, Ms. Pratt or Ms. Wilson from the committee? Okay. Is there anyone else in the audience who would like to come forward and to speak to this application? All right, I'm not seeing anybody come forward. So with that, I think members of the committee were We're ready for a vote. So I think I already know Mr. White is dissenting on this application. Those those in favor, please. All right. For the record, I also will be supporting the application. So we have 3 supports and 1 dissent on that application, which means, Mr. Segreto, as you know, that the application is granted. We talked a lot about the trees tonight, Mr. Segreto. We heard a lot of really positive things about retaining as much as we can. So I'm going to hope that that in fact does occur in the fullness of time, and that we can retain in particular that tree number 6, and I guess it's 4, and there's a few others. So let's make that happen. Thank you very much, Mr. Segreto, for at least, I think you know the committee well enough to know to be working on these things as you come forward. So we appreciate that.
Thank you, Madam Chair. Thank you, committee members. Thank you.
All right, thanks. Okay, we're going to go to application, let's see, number 3 and 4 at this point. Number 3 and 4, I'm looking for Mr. West.
Good evening.
Good evening, Mr. West. So before we get started, I don't have a stat deck from you. So can you either swear or affirm that the sign provided to you as part of the process and by the committee was posted on the property to which the application applies for the prescribed number of days prior to the hearing, and that that sign was at all times clearly visible and legible? Can you either swear or affirm that to be true?
I swear.
All right, thank you. Before we get to, we're not going to need a presentation from you, Mr. West. And oh, good evening, Mr. Chown. Just notice that you're also with us. Sometimes I don't see the whole screen at once, especially if you're on opposite sides of it. Just want to make a couple of corrections to the notice. My understanding is that with respect to variance B, we are saying to permit a lot coverage of 35% or 160, which is now revised to 33% or 151 square meters. Is that correct?
Correct.
All right. The other one I had a question for you on this was actually variance D. So I've noticed on variance D that we have the same sort of thing. So we're striking 30% and replacing it with 28.7. And yet I don't have anything in terms of the square meters, any proposed changes to that. Can you just confirm what the figures for variance D, please?
I apologize. You have it marked as it was 30 and it's been brought down to 28.
28.7.
Right. So in our discussions with Committee of Adjustment staff, we originally came into this application with a lot coverage of 30%. We had rounded up just in the in the abundance of caution, and municipal staff, or committee staff rather, had requested that it go down to 28.7, I believe was what you said.
All right. And Mr. West, you have a total square meters for me that correspond with that 28.7?
I would just have to check my email 1 second. I do believe I have that calculated.
All right.
Madam Chair, I don't think the square footage has changed. As Mr. West was saying, it was just a rounding exercise for the coverage.
All right. I'm going to get Mr. Hodgins to come forward and confirm one way or the other, please.
Thank you, Madam Chair. Staff commented on the lot coverage. It looked like it was rounded, so we just wanted to clarify that. We did not clarify the square meterage, as we don't have that exact numbers. We just had building footprints on the survey plan. So our concern was really just to correct it based on what was shown on the plan, showing the minor variances.
Well, if we don't, so I think what I'm hearing then is that 134 may or may not be the right number. Mr. Chown tells me that it is the right number, but I'd like to hear that from you, Mr. Hodgins, and Mr. West.
we would be comfortable applying for the 30% and the, excuse me, rather. We'd be comfortable applying with a 30% and the 134 square meters. That's the conservative way to go.
All right, Mr. Hodgins, would you be prepared to accept that?
Through you, Madam Chair, yes, it's a greater lot coverage, so I don't see an issue with that.
And the notice went out at 30% in any event, right? So we're not changing the notice in any way. All right. Okay. All right. So in that case, I am not going to amend variance D in accordance with my notes. Okay. I have one more to do on this, and it has to do with the legal description. Mr. West, I'll be looking for a response from you. My understanding is we're talking about part of Lot 11, Ottawa Front Concession 1. Is that correct?
Correct.
All right. Thank you, Mr. West. Mr. White, I see your hand is up.
Thank you, Madam Chair. Just a quick question. The report mentions this extension of sanitary sewer along James Cummings Avenue. I wonder if I could get a little more information on where that's coming from and what the how the services are being introduced. I would note that I believe that adjacent more recent plan of subdivision on, I think it's called Cyrus Court, is a fully serviced plan of subdivision, but historically these are partial serviced lots, and just wondering where the services are coming from there.
All right, Mr. West, over to you.
I'll let Mr. Chown answer this question. I believe he has more information on this than I do.
All right, thank you.
Thank you. So the James Cummings is already serviced with water, and the sanitary sewer is on Carling Avenue, so it needs to be extended along James Cumming from Carling Avenue.
Okay. Thank you.
Any other questions for either Mr. Chown or Mr. West? All right, I'm not seeing any further questions from the members of the panel. And I don't have anyone on deck to speak, according to my list. Is there anyone in the audience who would like to speak either for or against this application? This would be your chance. It's for an application for consent and minor variance. Yes, I see that we have Mr. Is it Kesmi?
Yes.
So can I have your full name and your address for the record, please?
Yeah, I am a consultant for the owner. So my full name is Maziar Kasemi, Qasemi.
All right, and the municipal address out of which you work?
For the owner, I am consulting him.
I'm just asking you for your municipal address from where you work.
Okay, for 101 James Cummings.
James Cummings, okay.
Yeah.
All right, thanks so much.
No problem.
So is there anyone in the audience though that has an interest in this application that would like to speak either for or against? All right, I don't see anyone raising their hand or coming forward. So at this point, committee members, anybody have any final questions before we go to a vote? Okay, I'm not seeing any questions. All right, so on the consent application, all those in favor? All right, so for the record, the consent application is granted unanimously. And on the minor variance, all those in favor? All right, same thing for the record, the minor variances, plural, are granted and it is unanimous. So Mr. West, Mr. Chown, I see that there are a number of different conditions of development that need to be fulfilled as part of this approval. Any questions or discussion required on any of those?
Madam Chair, if I may, we did have one comment with respect to, I believe it's condition number 2. Let me just check my notes here. Yes, condition number 2. We've had an exchange with Mr. Hodgins with respect to condition 2, and he informs us that this is a standard condition on corner lots that are taking advantages of some of the special zoning provisions with respect to the severance of corner lots. But, you know, the point is that the zoning provisions in the bylaw already require that the two homes face onto different streets. So I'm not sure why the staff are asking for a condition for us to enter into an agreement that says we're going to abide by the zoning bylaw. The zoning bylaw already has the requirement for the new home to face onto Merle Street. Otherwise, you don't get a building permit. So it's not at all clear to us why staff are asking for condition number 2.
All right, fair question, Mr. Chown. Mr. Hodgins, can you provide some clarity?
Thank you, Madam Chair. It is correct that for severances taking advantage of the alternative lot area provisions, we do request this condition. The difficulty is when they go to the building permit stage, it may not be abundantly clear that the severance that has taken place to create this lot made use of those alternative lot area provisions. So to ensure compliance with the zoning bylaw and to make the owner aware of this requirement, that is why the condition is requested. We will leave it at the discretion of the committee to include the condition or not.
All right, so it's actually, I'm not sure why it's an abundance of caution kind of thing. So if I'm understanding you correctly, once the lots are created, if there isn't this kind of condition, then there can be an application for a building permit on one or the other lot, doesn't matter. And whomever is examining those plans may or may not be aware that those zoning provisions actually apply to these lots, and they won't know that or be able to apply it unless there's this development agreement that they can rely on. Is that the case? Is that what I'm understanding?
Correct.
If I may, Madam Chair, the plans examiner will have in front of them the record of the applications on this property, which would include the consent application. It would be abundantly clear to the plans examiner that this lot was created by consent. If the committee feels that they need to do something in the abundance of caution, we would suggest that you tie the approval to plans rather than impose this condition. It's just a waste of time and money.
That's a good suggestion, Mr. Chown. As a matter of fact, and by tying it to plans, we should have no problem with that. So members of the committee, we've never really seen this before. Any thoughts, any concerns about deleting it by any chance? Mr. White.
Thank you, Madam Chair. I'm inclined to agree with Mr. Chown. It sounds as if this would, if we impose this condition, it would require an additional agreement to be registered on title, or is the intent that, maybe staff can answer this one, is the intent that provision be included in an overall agreement, which includes the infrastructure issues as well? I agree with Mr. Chown. I see the zoning bylaw is pretty clear. If a zoning examiner can't deal with the zoning provisions that he's looking at when he's looking at a plan, there's something not working properly.
So,
but
White, I mean, I do agree with you on that too. But I do want to say, I don't know if you recall, because we had this discussion. There was a bit of frustration on a number of the panels about the way some of these conditions were coming through. And what we were seeing often was condition to enter into a development agreement for X, condition to enter into a development agreement for Y, and so on and so on. So we actually had gone back to the planning department and said, can you please have one agreement and then itemize everything that should be in that agreement, hoping that we would get that this would all be very clear to everybody. And I don't know if you recall, but we were actually told that was not was in fact not recommended, and that the conditions needed to stand on their own. And because of that, there would have to be the wording. But in practicality, the way that they would actually draft the agreement would be to include all of these other things. So it's not multiple agreements against title, one agreement against title with all of these multiple aspects, but the conditions would be worded differently, would be separated. Anyway, it was, to me, it seemed so much cleaner to be able to put them all under one, but apparently that's not recommended, like I said. So
that being the case, then, Madam Chair, I have no problem deleting the condition number 2.
All right. Other thoughts, Ms. Willis, Mr. Handel? Mr. Handel?
Yeah, I like the idea of tying to plans in this case, so it can kind of achieve the ends without the need for an agreement necessarily.
All right. And Ms. Willis, are you in support of that approach?
I always like eliminating conditions if we can. Tying it to the plan, this might be a really stupid question, but I'm a bit perplexed. If ever there is an adjustment to an addition onto this house at some point in future and we tie it to plans, does that mean they have to come back to the committee for the variances that have already been approved?
If I may offer an opinion on that, Madam Chair.
I just let me give me a run at this, because the thought that kind of went through my mind, Ms. Willis, when you said that was, so we're just trying to create the lots. So if by the time, so it's kind of a moot point, I think, because once they've actually got their building permits to move forward with the development of those lots, if they make changes in the future, it won't affect the approval and the creation of the lot in any way. Mr. Chow, go ahead. Maybe I missed it.
I was going to say, because of the lot coverage provision, any addition, we're going to be back to the committee.
And that's, I guess, the other. Anyhow, any concerns then, Ms. Willis, on this? Because I would be tempted to delete it.
No, I'm not concerned about it, deleting it.
All right. Okay. So for the record, we are going to delete condition number 2 and simply renumber them 1 through, I guess it's going to be 9 now. Yes. I do want to ask, though, Mr. Garnett, if you will, just to be sure that we can share and have committee discussion on this. Could we be sure to take note that we would like to bring this forward to a committee of the whole at some point so that we can understand the processes and make sure that, in fact, we're not falling into a pit hole here for whatever reason. So I'd like that added to as an agenda item, please, if we could.
Noted, Madam Chair. Thank you.
All right, thank you. I think that concludes these applications. Any final words?
Thank you very much, Madam Chair, members of committee.
Thank you. Have a good evening.
All right, thanks so much. Okay. So we're going to go to item number 5 next. And I'm looking for, that's 138 Britannia, for Ms. van der Velden. Good evening. We just need you to you're on mute. You're on mute.
Okay, thank you.
So we don't have a statutory declaration for you, so I'm going to have to ask you to respond. So the sign that was provided to you as part of the process and by the committee, can you please tell me whether you can affirm or swear that it was posted on the subject property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that the sign was clearly visible and legible for the entirety of that time? You can either swear or affirm.
I swear that to be true.
All right, thank you. So Ms. van der Velden, you're a consultant, is that correct?
No, I'm the owner.
Oh, you're the owner. Okay, so I apologize, because for me, it got a little bit confusing at one point because I think there was some numbering. There's 2 applications on Britannia tonight, and I think that's what happened.
Yep.
So, okay. So we don't need a presentation from you. This is a permission application, folks, so a little bit different. I do need, however, to make a minor housekeeping amendment to the legal description. I'm going to read this out and you can tell me if that's correct or not. So for the legal description, we're talking about part of lot 15 registered plan 40 and a half. That's a new one on me, I think. Part 1 on 4R 9310. Is that correct?
That's correct. So when I originally applied, I didn't include the part of, and I believe that that's been added.
Yes, it has. Okay, and so has the 4R plan. So that's good. Okay. Members of the committee, any questions at this point? It's pretty straightforward.
Yay.
Mr. White.
Thank you, Madam Chair. Sorry. Just a point of order here in terms of we don't deal with a lot of these applications, as you're aware, but and the applicant has cited the 4 tests under the Planning Act for minor variance approvals. In the case of the permission, it's my understanding, I believe we got some information from the city solicitor on this, that the proposal for enlargement or extension of what essentially is legal non-conforming use does really not have any criteria that we need to that we have to consider, save and except that the building continued to be or enjoys legal non-conforming rights. So there really is no criteria that we must have regard to in terms of the approval of this application. We just have to be satisfied that we are in fact dealing with a legal non-conforming situation.
All right, Ms. Ramirez, did you want to confirm that?
Thank you, Madam Chair. Member White is correct that the 4 tests of the Planning Act don't need to be satisfied. Those are for the minor variance, but we do have to, the committee has to weigh if the permission is desirable and the impact to the community. And so those would be the tests to evaluate the permission against.
Yeah, I do recall that slight qualifier, Mr. White.
Madam Chair, I don't see that in the Planning Act. That section 45 2(1). 2I.
Do you by any chance have the legal opinion that we got on that? Because we do have a legal opinion.
I'm just looking at the Planning Act wording for permission, that's all. I don't recall the legal opinion that we were given, but in any case, I don't think it's a problem.
All right, Ms. Ramirez, I saw that your hand was up.
Madam Chair, it is established through case law, and it's been, I want to say it's this, I referenced the case in my report, but it has been established through the case law.
All right, thank you, Ms. Ramirez. That is helpful. Any further questions? Anybody on the committee? Any concerns about it being undesirable and not minor? No, I think everybody's seems to be pretty comfortable with it. Mr. White, do you have any further questions? Any reservations? No? All right. Okay. In that case, I don't have anyone on deck to speak to this application for permission. So is there anyone in the audience who would like to speak either for or against the application for permission at 138 Britannia Road? All right, I'm not seeing anybody come forward. That given, committee members, we can go to a vote. All those in favor? All right, for the record, the application is granted unanimously by the committee. Thank you, Ms. van der Velden. I hope I've got that right. And thanks for and well, good luck with your project.
Thanks so much, and thanks for taking the time tonight.
No problem. We're here for that. So thank you.
Thank you. Bye-bye. Bye
now. All right. What's next? We're going to application number 6 on 2292 Prospect, and I believe I'm looking for the agents. I've got 2 names, Mr. Bisson and Ms. DeSanti.
Good evening, Madam Chair, members of committee. My name is Nadia DeSanti. I'm the agent on behalf of the Ottawa General Contractors.
All right, and you will be answering questions this evening?
Yes.
All right, because I know I've got the two names, so I wasn't sure if there was one over the other. So we do have your stat deck, so we don't need to go through that. We don't need a presentation. The committee's had a chance to look at the file. Is there any questions for the committee at this point for Ms. DeSanti? This is a quiet application. Okay.
I'll take it.
Yeah, and I'm just looking to see, Ms. DeSanti, if there's anything that we need to address. There is. Why do I have something about housekeeping for? Okay, do I have a housekeeping amendment here that's required? Just give me a minute. I don't want to miss it in case it's there. Nope, must have been on another application then. Okay, so no amendments that I can see. Okay. All right, and there's no questions from the committee. So, and I have no one on deck to speak to this application. So I'm going to make a call out to the audience. Is there anyone who would like to speak either for or against this application? You just need to raise your hand and come forward. Not seeing anybody come forward at all. So that being the case, I think we can go straight to a vote. Members, all those in favor? All right, okay. Well, with that, then Ms. DeSanti, your application is granted unanimously for the record. And I don't think there's anything else we need to discuss. So thank you.
Thank you very much. Have a good evening.
You too. Bye now.
Bye.
Okay. The next application then that we would like to go to is application number 2, which is for 2525 Lancaster Road. And I believe I'm looking for Mr. Chatter. Yeah, Mr. Chatter. Sorry, pardon me, just got to get my lists together. Good evening.
Good evening, Madam Chair.
I think, are now.
I also have Ms. Gabrielle Snow from my office. I think she's on as well.
Okay. Yes, I do remember seeing Ms. Snow's name on the report. Okay.
And our clients are available if you need any questions of them as well.
All right, so I think, Mr. Chatter, this is one application for which we will want a presentation. So I'm not sure if it's going to be Ms. Snow or yourself.
I'll let Ms. Snow handle it for us.
All right, Ms. Snow, the floor is yours.
Great, thank you.
And we did provide a short presentation.
Sorry, Madam. Perfect.
I think we need the sworn oath.
Sorry, what was that?
Nope, please go ahead.
Are we? Okay, great. So before presenting, I would just like to introduce everybody else on the call. So you've heard from Tim Chatter. He and I are from Jail Richards, and we're agents on the file. On the phone is also Mark Savinsky. He is the owner. We have Jill Norman from Glenview Homes and Michael Pollowin from Gowlings. So we could go to the next slide, please. So the address associated to this file is 2525 Lancaster Road in Ottawa, Ontario. It's owned by OAC Holdings Limited. We're looking for reciprocal consents to sever the subject property into 2 new properties. So this will allow for the sale of the smaller of the 2 severed lots at said property. If we can maybe go to the next slide, please. So this is just the location of the property here. If we could go to the next slide, that would be great. So here's some pictures of the retained portion of the property. So here we see both the existing OAC building as well as a warehouse and parking. Next slide, please. So this is the severance plan. If we go to the next slide, we can show the different portions of said application. Perfect. So the total area of the subject property is about 3.24 hectares. It's located within the urban boundary of the city of Ottawa and is zoned light industrial in the entirety of the lot. The retained parcel is approximately 2.4 hectares and has about, or will have about 210.34 meters of frontage on Lancaster Road. It contains a warehouse, the existing OSC building, and parking. The retained parcel consists of parts 1, 3, 4, 6, and 7 on the severance plan. And that's basically what we see as application 1, or the large lot on this property. The severed property will be about 0.84 hectares and will have about just under 50 meters of frontage on Lancaster and is currently vacant. It will consist of parts 2, 5, and 8 on the severance plan. There's also a proposed easement on the retained property, which will serve as a second access to the severed property once it's developed. And the easement consists of parts 4 and 7 on the severance plan. So that's what I had prepared for the presentation. If there are any questions, I'd be happy to answer, and so would the others on the line if they're better positioned to answer.
All right, thank you, Ms. Snow. I think the committee will have some questions on this application, so going to open it up to them at this point. Ms. Willis.
Yes, thank you, Madam Chair. Just with regard to the existing site plan on the site for the athletic club, does it cover both the severed and retained parts as part of a previously approved site plan application?
The site plan that was associated with the OAC was removed in the fall of last year. So there is no site plan agreement on the site.
So there's no, is there in fact then a requirement to go through site plan approval?
We're having that discussion with the city staff right now because
surprise.
They pulled a building permit last fall for a renovation to convert it from the OAC to an office and warehouse structure, which was issued. And we were of the understanding that it included all the information related to the site as well. So that's what we're just clarifying between building services and planning right now.
And just so I understand this a little better. So for what reason was the site plan removed from the site?
It was done before we were retained on the file at the end of 2020. I believe it was just a precautionary measure by the owner at the time, just in case they were going to do something that we didn't actually have to deal with a site plan.
And do you know whether or not that previous site plan did cover both properties?
I would assume it did because it was a single property at that time. And it did indeed have some of the parking that it was associated with the OAC.
Okay. That really clarifies. Thank you.
Well, any other questions, Mr. White?
Thank you, Madam Chair. Did I hear that Mr. Paulowin is in the is available?
He is available if we need him, Mr. White. If I can answer the question, I'll do so. We just had him on. We could call him if we needed him for something specific.
I don't think we'll bother him necessarily, but I'm assuming that he could probably answer the questions with respect to the site plan agreement history on it and why the unless staff can provide some input, but I would assume he might have some background to that if we really need to know it.
Well, Mr. White, I think that's a good point, and I was actually going to ask Ms. Ramirez. I'm sure she's done a little bit of homework on this and might be able to give us a better sort of timeline on the history of the site. So Ms. Ramirez, please go ahead.
Thank you, Madam Chair. I didn't pull the old site plan as it had been noted that it was removed from the title. I did look into the building permits and the history of those, and to date there have been 3 building permits that have been been issued. The first one was for interior demolition. The second one was for interior alterations. And then the second one, or the third one, was for the water connection to the site.
Mr. White, go ahead.
Yeah, Madam Chair, I would assume that in issuing the building permit, that staff would have analyzed, and maybe this is a question I'm asking, would have analyzed the conformity of the existing development with zoning requirements. And just to carry on from that, I'm assuming that the existing the warehouse conversion, along with the parking that is provided in association with that, will conform to the zoning bylaw on its own, and that subsequently, if there is a development proposal that comes forward on the vacant parcel, the severed parcel, that will be subject to site plan control. I mean, that being the case, I don't see any problem here with an approval based on the existing approvals that have already gone before under the building permit situation.
And Mr. White, we have confirmed with our review of the site plan for the existing OAC portion of the property that it does conform to the bylaw for all of the requirements for parking, loading, bicycle parking, etc.
All right, so does that then, Ms. Ramirez, satisfy one of the points raised in your report where you request that that the applicant provide that the information you were looking for with regards to triggering site plan control? Or do you now have the information that you were looking for?
Through you, Madam Chair, the proposal complies with the zoning and how it is the zoning requirements for the conversion of the warehouse. The grading and drainage has not been looked at. It wasn't looked at through that previous permit for interior alterations. And that's one of the things that site plan would review, the grading and drainage. And we've included it as a condition. And if it's determined that the site plan is not required for that conversion that took place for the parking lot, we would let the committee know that it was not required. But because site plan can and has been waived in the past for parking lots, but at this point, the grading and drainage is one of those aspects that we look at during site plan that would need to be looked at again. And we have the grading and drainage condition, but if something comes out of that review that needs more work, we have the condition regarding site plan that we are requesting from the committee of adjustment.
All right, I'm still trying to figure out sorry, go ahead, Ms. Wallace.
I'm sort of confused as to how a building permit can be issued when a facility of this, first of all, I'm assuming it's a change of use from an athletic facility to a warehouse. So I'm just sort of cautious about how somebody must have done a check to determine, as you were saying, that the zoning requirements are met, but are all the modern requirements with regard to access and egress and landscaping and all that sort of thing that are not necessarily bylaw driven, but are dealt with through site plan approval process? Are they not part of a process that would be required to change what was a previously approved site plan to what will become two separate sites? I'm with reciprocal easements and just a bit, I just don't understand. I don't understand this and how we can be dealing with this before we know whether or not site plan approval is required. And if there is site plan approval requirement, how it might change the actual configuration rather than just cutting it off on the new property line. So I'm wondering, I guess, from staff, what do you even look at in terms of trying to determine whether it's appropriate development?
Madam Chair, we would really be focusing on the grading and drainage as part of this site plan. You're correct that other aspects that can be looked at is pedestrian access and landscaping. We acknowledge that been built already, this parking lot, and that we really need to satisfy that we are okay with the grading and drainage, and there has been a plan that's been submitted. It will be looked at following the decision from the Committee of Adjustment, and if more work needs to be done regarding the grading and drainage, that's why we're asking for that additional condition regarding the site plan, because that will give us a little bit more.
So just follow up. Who determines whether site plan is required?
So generally, there is a pre-consultation that takes place with the city. Generally, a request for a site plan requires a formal pre-consultation, and it's generally sent to the senior planner for the area, and then they assign it to a planner. Site plan approval can get waived. If it needs it, it can get waived. It depends on what the benefits are to us of putting applicants through that process.
And did that process occur?
Site plan control has not been waived. It was not waived in this case.
It just strikes me that if site plan, if it's determined, and I haven't really got an opinion, except I find it confusing that if site plan approval is required, then we're sort of putting the cart before the horse in terms of these applications that are before us.
I guess I could
agree with Ms. Willis on that. To be honest with you, I'm looking at this and I'm thinking, all right, I'm even questioning, the need for number 3 at all in some ways, if that's already been determined. So I've got a number of people who want to weigh in on this. I see so Mr. White, if you will just give Ms. Normand, and I'd like to know, remind me who you are in the process so that I know. Are you a consultant? Are you?
Good evening. My name is Jillian Normand. I'm Vice President at Glenview Homes, and I'm representing OAC Holdings under the same ownership. So I just thought I would chime in to provide some clarity on this. So essentially, we have received building permits, a couple of building permits at this point in time, starting in September 2020, and that was for the conversion of the OAC building into the warehouse. And at that time, we had submitted a site plan to confirm that the change would comply with zoning, as well as all of the warehouse and office use requirements. And then we also submitted a drainage and grading plan. And at that time, along with the architectural plans, and at that time, we received stamped drawings for the site grading and drainage plan, as well as a site plan, as well as for the architectural drawings. So we were of the understanding that all of these items, all of these plans had been reviewed as part of that building permit issuance. And at this time, it has come forward to us recently that the city is just inquiring whether or not they did a detailed review of the grading and drainage. But we do indeed have stamped site grading and drainage plans, as well as site plan.
As well as the site plan, but you didn't go through the site plan approval process.
No, we had, it was a different individual, our construction manager. He was coordinating the building permits, and he submitted everything through our architect, through our civil engineer, all of the typical plans that would be required to be reviewed during the building permit process. And as far as they understood it, everything that they had proposed was crystal clear on the plans, and they had stamped a city stamp on those plans before they commenced, and they received a building permit tying those plans to the building permit.
All right, thank you, Mrs. Norman. I've got 3 in line here. So I'm going to go to Mr. White, Ms. Ramirez, and then Ms. Willis.
Thank you, Madam Chair. So it's my understanding that there was a site plan agreement that was registered on title to the original development. For whatever reason, the city chose to or agreed to have that site plan agreement removed from title in the absence of any subsequent development application or application for site plan control. So that original site plan agreement would have included all the provisions of grade control, drainage, parking layouts, all that sort of thing, based on the development that existed prior to the new redevelopment of the OAC building to a warehouse. Permits were issued for the warehouse conversion in the absence of any requirement for site plan control. From what Ms. Norman has indicated, a grade control and drainage plan and a plan for the parking lot was reviewed at some level and approved by the city. It strikes me that there is an approval in place for the existing redevelopment of the warehouse. And as I mentioned previously, any new development that takes place on the vacant portion, the former parking lot, will be subject to site plan control. So in my opinion, just looking at it, I see no reason why further site plan approval is required on the converted OAC building. Cities waived the opportunity to require that by issuing the permits that they've already issued. And they will have an opportunity at the time of redevelopment of the vacant parcel to put that portion of the land through site plan control. So, I mean, I don't think it's incumbent upon us to require delay in this application to have a site plan process imposed on something that's already been approved by the city.
Mr. White, you raised some good points. I mean, I think the approval sounds like it's completely on the building side and not the planning side. All those documents were provided on the building side. I don't think I heard that there was actually a pre-consult and that the city made the decision not to go forward with the site plan process for the redevelopment of the site. I don't think I heard that. I'm going to go to Ms. Ramirez, and then I'm going to go to Ms. Willis.
Thank you, Madam Chair. I want to just reiterate that there have been 3 building permits that have been issued for this warehouse conversion. The first one was for interior demolition. The second one was for interior alterations. And at that time, there was a review that took place to see whether it complied with the zoning. And there was also a review that took place to see if it conformed with the building code. The grading and drainage was not looked at that point. So the approvals were for whether or not it conformed with the zoning bylaw and whether or not it conformed with the building code.
All right. So if I understand this correctly, there's different types of building permits that are issued. There's demolition. It sounds like there's also, and I don't profess to know all the different categories of building permits you can get, but it sounds like interior alterations, none of which necessarily speaks to redevelopment on the site. It's simply just a redevelopment of the asset itself. So I think from a redevelopment standpoint, though, for the purposes of looking at all of the other things that would not just interior kinds of renovations, but loading zones, parking requirements, landscaping, whatever it is, do I have this right that there's been no real review of that, and the types of permits that were applied for would not necessarily have triggered that in any event? I totally misunderstood.
Through you, Madam Chair, the plan that was showing, that was presented during that second building permit showed that there was sufficient parking on site. So I believe that that's what the plans examiner looked at. The parking lot itself wasn't looked at for configuration and grading and drainage. Member White is correct that the new parcel, should it be redeveloped and trigger site plan control, that new parcel would go through site plan control. And so I will just reiterate that the parking lot grading and drainage did not go through site plan control. And there is always a possibility that site plan control would be waived for that parking lot reconfiguration that took place. We just don't know yet, though. And in the interest of moving this application forward, staff had changed its initial request for an adjournment to no concerns with the condition that if site plan control is required for that larger site, that we still have the ability to go through it for that parking area.
All right, thank you, Ms. Ramirez. Okay, so I have Mr. White, and then I have Mr. Chatter.
Sorry,
And
madam.
just before Mr. White, I will get to you in just a minute. I'm just going to throw something else in the hopper here, just so that, you know, I'm beginning to get the sense that that maybe we should be considering an adjournment, maybe not. But let's just also be mindful of the fact that there's also a request as part of the conditions here that the applicant, how's it worded exactly, that there needs to be confirmation in writing that the parcel has access to sufficient services and adequate capacity, which was another one, as you know, that we found was a little bit odd in all of this. So go ahead with your comments. I just wanted to make sure that we're kind of looking at a number of different issues here to determine what our best course of action is. So I'm going to go to Mr. White, then I'm going to go to Mr. Chatter, and then back to you, Ms. Willis.
Thank you, Madam Chair. Just a quick follow-up. I thought I heard from the applicant that there was a review of the parking lot grading plan in association with the building permits that were issued for the conversion to the warehouse use. Getting a different story from staff perspective. I'm just being confused.
I think, Mr. White, your comment is valid because the documentation was reviewed by the building department, by building services. It was not reviewed by the planning department. So we have the two different groups who are looking at this. So it was not reviewed by planning for any purpose under what we would normally review under site plan. It was simply reviewed by building permit staff to make sure that it conformed to the zoning bylaw for all of the matters that are included in the zoning bylaw. So setbacks, number of loading spaces, proper access to the loading spaces for turning radiuses, fire code access, number of parking spaces, make sure the spaces and the lanes all conform to the bylaw. So there was a thorough zoning review done by the building services group, but not by planning.
That's interesting. Thank you. All right, so Ms. Ramirez, I do see that your hand is up, but I think I'd like to go to Ms. Willis because she also had her hand up earlier.
I'm still I'm trying to figure out sort of the order of events and wondering whether or not I can sort of see how things might be confusing to the building department if they had seen there was a site plan on the site, and if this is the building permit applications were simply for interior renovations, that they wouldn't even consider looking at the site plan because it's simply building permit. But had the site plan already been removed from the site, and was the building department aware that a severance was coming, which would result in some changes to the parking area? There's going to have to be if the parking lot extended onto the other property, they're going to have to close that off. And I know that there's going to be joint access. That's hence the easement agreement, but it's going to result in changes physically on the ground, which will impact, I assume, the existing site as well. If for no other reason that a whole bunch of parking spaces come off, even though there's no site plan applicable to the site anymore. So I think I need clarification first as to the order of events and whether or not the site plan had been removed well before and to the full knowledge of the building department when they stamped the drawings, just sort of saying, yeah, they may have thought they complied with the site plan that had been previously approved.
No, site plan was removed first. It was gone before there were building permit applications. So it was removed before any of this started to take place. Then the building permit applications went in. And the zoning reviewers at buildings do look at the questions related to the zoning bylaw because they can't issue a building permit unless the site conforms to the zoning. So they won't have site plan to rely upon, but they do confirm zoning before they issue a permit. Did they include the entirety of the property? Yes, they did.
Did they did not know that there was a severance forthcoming?
No, because when they issued the permits, there was no application for severance. And there hadn't been any indication that there was going to be an application. So what we did as part of the review with Ms. Ramirez was to confirm that once the severance line gets drawn, the OAC warehouse still conforms to the requirements of the zoning bylaw. So we've confirmed that there's enough parking and enough loading in accordance with the drawing that buildings reviewed to show enough parking and loading.
All right, thank you. I'm going to go to Ms. Ramirez. She's been waiting patiently.
Thank you, Madam Chair. I just wanted to let the committee know that I did take a look at the tasking of that building permit for those interior alterations, and in there it notes that no grading and drainage review was done.
All right, I find that interesting because I totally hear what Mr. Chatter was saying about the grading and drainage looked at by the building folks or building department for the purposes of the building permit issuance, and the difference between a grading and drainage plan that needs to be looked at from a development standpoint. It's a little bit different process. I'm not sure if it's a different internal review process. I'd actually have to look at some of my friends from that have worked with the city in the past or for the city in the past. But so that for me is really unclear at this point, to be perfectly honest. I did see Mr. Pollowin's hand up at one point, so we can always bring him into the discussion. Mr. Pollowin, are you still there? Ah, maybe he's disappeared. No.
He's still on mute, but he's there.
He's here.
Yeah, no, I do see him. I do see him now. I saw him, then I lost sight of him. So lost sight of his name. That's all I actually see, like the rest of you. So, Mr. Pollowin?
I'm here. The way, Madam Chair, the way your system works is it puts you on YouTube to wait. And then when you get admitted by the system, it boots you off and brings you back in. So that's why I disappeared.
Ah, okay, good to know. We've not been on that receiving end, so thank you for that.
You're welcome.
Description.
How can I help you? I understand Mr. White had some questions.
Mr. White, did you want to?
Thank you, Michael. Good to talk to you. I'm a little confused with how the city has dealt with this conversion of the existing building from the OAC use to the warehouse use, and obviously the development of some new parking spaces on that portion of the site. Normally, in my experience, development of a parking lot like that with some change in use of a building would normally be subject to some kind of site plan control process, or at least consideration of site planning issues before the permit was issued. Now, it appears that the city chose to quit claim the existing site plan agreement that was registered on title some years ago when the OAC, I guess, first developed. They did not choose at that time to do an amending agreement or a new site plan agreement to allow the conversion of the warehouse and the redevelopment of the parking lot. I'm a bit surprised that that didn't happen, or the city didn't take that approach. But it seems to me that, notwithstanding that there have been approvals issued, and I think I've heard from people on your team that approvals were issued, permits were issued. There was some, or may not have been some review of the grade control and drainage and things associated with the new parking space. But also given that those permits are issued, it looks like the building's close to being occupied and used for the warehouse uses in accordance with permits that have already been issued. Any new development that takes place on the severed parcel is going to be automatically subject to site plan control. So it seems to me that all of your approvals are in place for the warehouse building. We're being asked to simply provide the severance, approve the severance of the vacant parcel, which will be subject to site plan control. And I'm not really in the habit of agreeing with imposing significant conditions on a retained parcel. I can understand conditions on the severed. So just wonder if you can clarify, is my understanding of what's gone on correct?
It is, and I can explain it. So at the time that this began, there was the possibility, but certainly no certainty of a severance of the parcel that is before you today. The question that was asked of me was, how do we do this conversion? And I asked some questions about, what's going to happen to the pool area and the tennis courts. I was told that there would be parking there. And my answer was, okay. So here's the thing. You have some 45-year-old site plan agreements on there. The city has a program for the removal of long fulfilled site plan agreements. If you move forward because your site plan agreements show parking, you will need to apply for an amendment to the site plan agreement. However, parking does not generate the need for a site plan agreement. The Planning Act provides that development in its definition includes the laying out of 4 or more commercial parking spaces, which the case law has held must be parking spaces that are paid for. That is to say, the kind that you will find in a public parking lot. If not, then it is not development. So my advice to the client was, let's get these, and there wasn't one, there were 4 of them. Let's get these ancient documents off. And then you won't have to apply for a site plan on the conversion. And this was done with the full knowledge of the city because it was complicated because there were 4 of them. And so I worked with the legal department at the city for 2 reasons. One was to make sure they understood what was going on. The other was it was taking far more time than it should have to get these things off. They had fallen between the cracks. So I spoke with the legal department and said, hey, look, can you fix this, please? So in terms of the need for a site plan agreement on the converted building, there wasn't one. Now the city is free to ask for, and my client will be happy to provide them information on the grading and drainage, but it's not required in terms of an approval from the city. And your synopsis of what will happen with any development on the severed parcel is absolutely correct. If anything gets built there, they're going to need a site plan. And if anything, if the committee sees fit to grant the severance, the interesting thing is these ancient site plan agreements would still be on there. And any person seeking to develop that 2-acre parcel would have to ask, as part of a site plan agreement, ask the city, please remove those. And they would have been removed because a site plan pertaining to the operation of the OAC will have nothing to do with whatever gets built there. And so it makes perfect sense. And it is my advice to clients in the normal course, if you have old site plan agreements and you have any thought of even restriping a parking lot, then take the site plan agreements off, because otherwise you're going to have to seek to amend them. But if you take it off, you don't have to. I hope that explains how this all works.
Thank you, Mr. Cowan. We appreciate that. It was helpful background for sure. I'm going to go to Ms. Ramirez, and then I think I'd like to go back to the committee and deciding what steps we're going to take next. Ms. Ramirez, you're getting the last word here.
Sorry, I'm on mute. I was on mute there. Thank you, Chair.
I never know if it's technology or it's just, one of these things that happens. So go ahead.
I just want to point out that the site plan control bylaw, section 5(3)(c)(4) states that you can do renovations to a non-residential use building if it's entirely contained within the building And also provided it doesn't create more than 9 new parking spaces. So I just want to highlight that this is within the site plan control bylaw, that had they not created 9 new parking spaces, site plan control would not have been triggered. But in reviewing the plans, to me, it seems like they added more than 9 parking spaces. And, and I just want to also say, site plan control has been waived before for parking lots. By having that condition there, it gives us that a little bit of extra authority. If we don't need to put this through site plan control for that parking lot that's been constructed, we won't. But that's why it's phrased that if we don't need to, then we can send confirmation to the Committee of Adjustment that it's not needed.
All right, thank you, Ms. Ramirez. Okay, Ms. Wallace.
Just a question for Mr. Paulin. Just trying to understand if you satisfied yourself through this process in consulting with the city that site plan approval is not required, why is it still a question as to whether site plan approval is required?
So I never posed that question, Ms. Willis. That was not part of my mandate. Having said that, Ms. Ramirez is quite right. That provision is in the site plan control bylaw, but it's not consistent with the Planning Act. The Planning Act basically says, in a word, I can put 50 parking spaces on, and it doesn't meet the definition of development under the Planning Act, but it is in the bylaw. Now, you know, obviously, if the committee sees fit to impose that condition, I'd encourage you not to. If the committee sees fit to impose that opinion, then my opinion that section of the site plan control bylaw is beyond the authority of the City of Ottawa is one that I'm going to have to express to the city's legal department at that time. But the issue of site plan was never the subject of our conversation.
So Mr. Paulin, just if it turns out that we go along with the recommended condition that staff is suggesting with regard to, if it turns out that the city determines that site plan approval is required, then you must get site plan approval and you must register that agreement presumably within a year of the severance. Is that something that you're agreeable to, that condition being imposed?
No, and here's why. Because the city doesn't require a condition of the committee to impose the obligation for site plan. The city has, if there is, let's just take the site plan control bylaw at face value. And on the issue of 9 spaces, okay? Let's take it at face value without my opinion as to whether it does or does not comply with the Planning Act. The city has the absolute right to impose the obligation for site plan approval. It doesn't need the committee to add that condition. So, I mean, I'll give you an example. I have a client who years ago actually built, you're not going to believe this, a multi-million-dollar building, and did so without site plan and without a building permit. And when I got wind of this, I said, you guys have a problem and we're going to need to go to the city. And I went to the city and I said, okay, not telling you who it is, but this is the situation. Will you guys agree if the client comes in voluntarily and discloses to simply treat it as if it was in the normal course? And they said, yes. Then they said, who is it? I said, I'm not telling you until we walk in the door. But the long and the short of it is, if the city of Ottawa, if Ms. Ramirez is correct, and if her superiors deign that it is required to do this, then they can require it. But our client has discussed with Mr. Moore, who is the file planner on this, and he has said, in his view, site plan control is not required. And so,
All right, thank you.
So
All right, thank you, Mr. Collin. Is there anything you'd like to add at this point? Because I'm thinking we've heard a lot about this at this point. I kind of want to wrap up discussion on this. We've asked an awful lot of questions. We haven't gone to the public hearing portion of this yet. So, and I don't believe I have anyone on the on my speakers list. So I'm going to make a call out. Is there anyone in the audience who would like to speak either for or against this application? Now's your chance. You've heard a lot of discussion. Not seeing anybody come forward. Okay, I'd like to address just the committee members at this point, because I think in a lot of ways what we've heard is that staff is asking for some of these conditions because in actual fact, the discussion between the applicants and the city has not concluded. That's what I'm hearing, is that there is some understanding about, and interpretations of things, but at the end of the day, I don't believe I heard from anybody that the discussion has ended and everybody's happy. Because if that were the case, then we wouldn't have the kinds of conditions that we have before us that we're being asked to include as part of the approval. So there's sort of two ways we can go about this, committee members. We can either say, you know what, this is premature, came too soon to us, you should have concluded your discussions. This has been educational, but at the end of the day, maybe the city staff should have resolved this with the applicants before it got to us. The other option is to say, we're going to give the benefit of the doubt to our planning staff who advises us on these things, and we're going to retain the conditions as worded in the staff report and deal with the application for either an approval or a refusal this evening. Want your thoughts on that? Mr. Hindle.
Sure. Thank you, Madam Chair. I think in this case, I'm prepared to move forward on a decision. I would tend to lean to keep the conditions in place if, as Mr. Baldwin indicated, that the staff planner on this application has indeed indicated that site plan is not required, then it should be a fairly easy condition to clear. So I would be most comfortable, I think, to leave the application with the conditions in place, and then the applicants can deal with them as they see fit.
All right, thank you, Mr. Hindle. Ms. Willis.
I think that's okay. I'm very concerned about creating a new parcel. The severance application is creating a separate parcel that is being tied. If we were to approve this, there's even an easement that's been identified for joint access. And how do we know that in the fullness of time in the adjacent parcel that maybe that's where the building's supposed to be located? And to go through reciprocal easements and a severance and a joint parking area and access without any sort of development proposal seems to me that it's premature. And it should, and it's sharing access with a site that doesn't even have a site plan. Like I just can't fathom how the joint development, and it has to be joint development of the two parcels if they're sharing access, can occur when there's no site plan in place and may never have to be a site plan in place for the existing warehouse. I don't know how it can be dealt with.
All right, thank you, Ms. Willis. Mr. White, I'm going to hear last words from you, and then I'm going to call a vote on either an adjournment or an approval. So go ahead, looking for your thoughts.
Thank you, Madam Chair. I don't have a problem with the application as it is submitted. As I've mentioned before, it's my view that the city has reviewed the question of site plan control through the issuance of permits for the conversion of the warehouse building. If there wasn't proper communication between the building and planning branches at that time, I think, in my view, that ship has sailed, and I don't see that there's in any case, any downside to the severance application. In terms of Ms. Willis's comment concerning the shared access, I believe that's something that can be resolved and amended if required at the time that site plan control is considered for the severed parcel. Well, I'm inclined to recommend that we approve this application without any condition relating to the requirement for site plan control on the warehouse converted component. There will be site plan control automatically on, as Mr. Paulins pointed out, automatically on development of the adjacent parcel. So the conditions I think that are included in relating to servicing plan and grading and drainage, I don't think I'm hearing any objections to those conditions from the applicants. So on that basis, I'm prepared to recommend that we approve the application on the basis of those conditions and leave the matter of site plan control for something that can be debated between the proponents and the city.
All right, thank you, Mr. White. I'm going to do what I guess I get to do because I'm the chair, and that's to have the last word on this. And after having listened to all of the discussion, I'm actually inclined to agree with Ms. Willis. So I'm going to do 2 votes. I'm going to vote to approve. Actually, we can do 3 votes. We're going to vote to approve the application as presented. We'll see how that goes. We'll then vote to, if it's approved, great. If it's not, then we'll move on to the next one, which is to approve it with removal of the condition for site plan. We'll see where that goes. And if all else fails, we're going to go to considering an adjournment on this application until some of these things can be resolved and brought back to the committee. So on that.
Sorry, Madam Chair, just can I ask you to clarify one thing? The second option about approving it, removing condition 3, is that what item 2 is? So that there is no option for staff to say, yes, site plan approval is required for the existing building?
That's what Mr. White is proposing in this case. So I just wanted to make sure that we had that as an option on the table.
So number 1 is then with the condition included.
Yeah, maybe we should do it the reverse. We go with Mr. White's proposal first, that we approve with the removal of the of condition number 3. See how that goes, and go to number 1 that I described, and then go to the adjournment. So let's call this. I just want to call this. All right. So on Mr. White's proposal, that we approve the application with that we grant the application, including the amendment of the conditions to remove number 3 regarding site plan. All those in favor? All right, so that fails. That's a motion. All right, all those in favor then of approving the application as proposed with the conditions outlined by staff. All those in favor? Okay, that's failing as well. So doing very well. So I'm going to suggest the third one is we're going to adjourn to, and I don't think this discussion would take that long and to get this resolved. So how about we would adjourn to the May 5th meeting to see whether or not further discussion on this can lay to rest one or the other, the requirement for a site plan and some other conditions. Now, Mr. White, I want to go to this vote because we could talk about this for hours, I think, at this point.
Sorry, Madam Chair, not to interrupt. Given that my recommendation did not pass, I think it's fair that, I mean, in the interest of the applicant who wants to move forward on this, I'm inclined to suggest, to support the second proposal, which would include the matter of site plan control, because it's my understanding that there may be an opportunity here to have that waived through discussions with staff. And I think that's a more preferable approach than delaying this matter and adjourning it for some future date. I would be open to hearing the applicant's comments on that.
Actually, no, Mr. White, I would rather actually go to staff because I don't even know procedurally if we can do that, because we did vote on it and it was clear there was only one person and 3 against it. So I need to hear actually from committee staff at this point whether that's a done thing. So Mr. Garnett, please, your thoughts on this.
Well, Madam Chair, I agree a vote was taken, but in any event, even if Mr. White changed his, Member White changed his vote at this point, I suspect based on the vote of the other members, it would be 2-2 and it would fail on a tie vote.
Yeah, thank you, Mr. Garnett, because that was the other thing, of course, there would only still be Mr. Hindle and yourself, which means it's still a fail on the vote. So, all right. So committee members, I think, I mean, here's the funny thing. All those in favor of deferring to May 5th, all those in favor?
Can I ask a question on that? I'm not clear to me, Madam Chair. Deferral until May 5th, pending what sort of is it a yay or a nay from the planning department that says, yes, site plan approval is required on the main site or not? Is that all we're waiting for?
Well, we would want that and an explanation that goes along with it that addresses some of your concerns, Ms. Willis.
Okay. And we're presumably we can get that by May 5th.
I think so.
Okay.
I think so.
All right.
Ms. Ramirez, do you see any reason why we wouldn't be able to get that kind of resolution by May 5th?
No, at this moment, I don't see a problem from getting the statement of whether or not site plan is or is not required.
And the explanation, we need to hear some rationale.
Yes.
There's been a lot of discussion we want to hear. If not, how all of it landed. And I suspect you're going to be involving some of legal services as part of your discussions as you go. So I do need to get a vote to know where we're going. So all those in favor of adjourning to May 5th to allow resolution of this issue. All right, that passes. So, oh my goodness. Thank you everyone though, because this is the kind of discussion that it helps us all grow and understand and see different points of view. And we certainly, appreciate Mr. Paulwin's explanation and his interpretations of things. It's not easy, it's not crystal clear. There's always multiple layers in these things. And so we look really forward to getting some clarity on all sides in writing for the next meeting so that we can deal with this a little more expeditiously. Thank you all for your time and your patience and your contributions to the discussion tonight. It is much appreciated and we look forward to seeing you in a couple of weeks.
Thank you, Madam Chair. We'll see you on the 5th.
All right, thank you. Okay, last but not least, 8 and 9, which is for 1551 Kingsdale Avenue. Who am I looking for on this application? The agent, sorry. Yeah, Mr. Guerra, thank you.
Sorry, hi, can you hear me now?
Yes, we can hear you. So I don't have a stat deck for your application, so I just need you to respond with regards to the sign that was provided to you and as part of the process and by the committee. Can you either affirm or swear that the sign was posted on the property to which the application applies, that it was there for the prescribed number of days under the Planning Act, and that it was clearly visible and legible for the entirety of that time? Can you either swear or affirm that to be true?
I swear that to be true.
All right, thank you. So we were going to require a presentation on this, but before I actually go there, I just need to one little minor housekeeping matter on the application. It would seem there was no issue with regards to the consent, but on the minor variances, I think the reference was a little confused. So just to be clear, that part 2 on draft for our plan filed with the minor variance applications essentially applies to the property known as 1549 Kingsdale, and the reverse is true for part 1, which is known to be municipally as 1551 Kingsdale Avenue. So it's just a minor correction. Can I just get you to confirm that?
Yes, that is correct.
All right, thank you. All right, folks, we're not going to go to a presentation on this evening. I think I'd prefer to go straight to committee questions on either the consent or the minor variance at this point.
I have a.
Yes, Ms. Willis.
Sorry, question of staff. On the existing driveway that's, I don't have the number in front of me, 8-point-some meters in width, would that driveway walkway combination comply with the zoning bylaw prior to the new provisions that were adopted back in October of 2020? In other words, was it built according, was its approval previously, was its construction previously approved?
Well, I purchased the house and the driveway was already there presently. So I can't answer that, but that's what the driveway size was at the time.
Sorry, that was a question for staff.
Oh, sorry.
That's okay.
Through you, Madam Chair, kind of a two-part answer is if the lands were not being severed, then the driveway would have been permitted. So we did take a look into that, and it was permitted, that front yard parking condition in that size under the former municipality of Gloucester's zoning bylaw. However, if the lands were severed prior to October 14th, 2020, I would have to verify the cutoff was 50% of front yard area for driveway coverage. So I would have to verify what that is, but it would be close. I believe they are close to 50%.
Thank you.
Any other questions on either the consent or the minor variances? We've got 4. I'm not seeing any further questions on these applications. I know it's been adjourned a number of times. We added for the purposes really of adding variance D. And okay, all right. So I do have a speaker that's on docket, Mr. Marcotte, and I see Mr. Marcotte is here. Mr. Marcotte, would you like to come forward? It's your opportunity to present your comments to the committee.
Yes. Can you hear me?
Yes, we can hear you.
Okay, yeah. All right, so there's a number of parts to this, and I only really want to speak to one of them, and that is the rear setback encroachment that's being proposed. So I'm
Go ahead.
Okay.
That's fine.
We're the neighbors immediately behind the property, the newly severed property if severance is granted. And we're concerned that the plan is for a building that encroaches on the setback by a nominal part of a meter, I think. And we just are questioning why that's necessary. And all things being the same, we'd rather the setbacks be respected.
All right, Mr. Garrett, can you answer that question?
Yeah, well, actually, I tried my best to make the house as small as I can. However, regarding the infill provision bylaw that came into place, I had to keep 40% front landscaping. So my house had to be pushed back more in order to maintain that new infill provision bylaw that came in October. I originally had it at 7.5. And I made it smaller because I would like a bigger backyard myself. So I feel that the 8 meters is not very, how would I say, it's very minor in nature compared to all the other several surrounding properties that have less rear yard setbacks than 8 meters. As I don't know if the committee could show, the coordinator can show slide 7 for me with regard to my presentation that I submitted.
Yep, we can do that.
Like I don't yeah, slide number 7. So that's the backyard that we're looking at, and I just don't feel how I would encroach on his property due to the 13-foot hedges that we have that we've been maintained for 20 years and the tree in the backyard. So I just don't feel going back a foot, it's actually a foot 9 inches back, would affect his view or his privacy or for him to enjoy his backyard. So that's, I did try my best to make the house as small as I can, and due to that infill bylaw provision there, I needed to keep my front lawn with 40% soft landscaping. So I had to move the house back in order to maintain that, because I know that was very important to the city. So that's the reason why.
All right, thank you, Mr. Guerra. Any other questions or comments, Mr. Marca?
No, I just recognize that it's not a profound difference for sure. And I have to admit, we don't have a lot of experience with Committee of Adjustment to know whether or not things that are this nominal, 20 inches or whatever it is, is a matter to be discussed or not. We recognize absolutely, we'd like to see our neighbor build on his lot to the extent that that's permitted. And to the extent that it's not permitted, well, there we have some questions.
All right, thank you, Mr. Marcotte. I'd have to tell you, this is actually, so for minor variances, actually, just what the thought that crossed my mind is it's not about percentages and change, it's about impact. And I think that that's what Mr. Guerra was trying to show us is the extent of, or how minor the impact is based on the photographs that he provided. So that's actually the right way to present evidence to the committee. So, Mr. White, go ahead, please.
Thank you, Madam Chair. Just in relation to the minor variance with respect to building setback, can I ask, maybe staff can help me with this one, the lot width here, how does it compare to in terms of the lot width? I'm thinking about it in terms of the area of the rear yard that's provided due to the width of the lot. How does it compare to the bylaw requirement and the sort of standard lot in this zone? I'm thinking in terms of is the rear yard area that's provided, can it be said to somewhat compensate for the minor variance of 17 or 18 inches, whatever it is, in the actual setback requirement?
Mr. Hodgins?
Through you, Madam Chair, Mr. White, actually, can I just get you to repeat the question? That would be helpful. Thank you.
Yeah, I'm just looking in terms of we're losing lot area theoretically due to the reduced depth of the unobstructed rear yard area. We're losing rear yard area because of that. But is that compensated for in terms of in any way in terms of the width, the width of the lot over and above what the bylaw minimum requirement is? You follow me on that?
Yes, in a way it could be. So the lot width requirement here is only 9 meters, and they're providing 14.68 meters in width. The rear yard requirement is a depth equal to 28% of the lot depth. So that's what's being varied here. There's also a 25% area requirement, which is maintained.
So is it fair to say then that the unobstructed area of the lot exceeds the bylaw requirement, or at least meets the bylaw requirement? If we notwithstanding the reduction in the actual rear yard setback?
Correct. It does meet the rear yard area requirement, just not the setback requirement.
Thank you.
All right, thank you, Mr. White. Any other questions? All right, is there anyone else in the audience who would like to come forward and speak either for or against this application? Okay, I'm not seeing anyone. So at this point, I think it's time for a vote. Members, on the consent. All those in favor? All right, so for the record, the application for consent is granted unanimously. And for the minor variances, all those in favor? All right, again, the application for minor variance is granted unanimously by the committee. There's a number of conditions, Mr. Guerra, that I note here, cash and lieu, independent services. These are fairly common and typical conditions, but did you want to raise any? Are they satisfactory to you?
No, they're satisfactory to me.
All right, thank you. In which case, I think that completes our discussion on this application. Thank you, Mr. Marcotte, for hanging in there. The last application took a lot longer than most of us thought it might take. So thanks for hanging in. And so I think the only remaining piece of business for the committee at this point is a motion to adjourn. Do I have a motion? Mr. Hindle, seconded by Mr. White. So we are adjourned for the evening. And